Nancy, I'll begin with you. The Trump administration has been using multiple levers to target all forms of immigration in this country, including de-documenting people who have been here legally, tried to do things the quote unquote right way. And it seems their strategy is working. How were they able to accomplish all of this in basically 11 months?
Some of it is a question of the framework, which is the legal framework, whereas police officers are accountable, particularly after the George Floyd demonstrations, accountable if they search your home without a warrant. The fruits of that can't be introduced in court. If they beat you up, you can sue them for damages. Not so with immigration officers. Not so with immigration officers. With ICE officers, if they search you illegally, the evidence can't be withheld from court, can't be suppressed in court unless the illegality was, as they say, egregious, which is a very high bar, because the Supreme Court said in 1994 that, the deportations were proceeding in a regular, careful way, that abuses were not widespread. That framework is what we have today when abuses are widespread. And you can't sue them for damages as you could for a police officer. So there is really, it's almost as if we have fought post-George Floyd to make police officers more accountable, more constrained, only to find that we have a completely unaccountable, unconstrained police force, ICE, in our midst.
Charles, on that accountability piece, what do you think the legacy, the impact of the rampant use of masks by this administration, the agents deployed by this administration, will be, and the impact that it's going to have over the next 3 years as this continues?
Well, Antonia, I think it has a very interesting sort of take on everything that we're watching unfold. And that is, to the last point, it really creates another barrier between the notion of the public and accountability for law enforcement in this regard. So ICE and DHS are not police. They are not law enforcement, yet we see them increasingly blurring the line between law enforcement, and it makes it more difficult to ascertain that line from an accountability standpoint when you talk about the mask and when you talk about how they're hidden. There was something that jumped out to me about your lead-in as you were talking about the entire setup that this administration has pushed with respect to their narrative. With what they are doing and who they are doing it to, they have created a space that has tacitly given them permission by the American people to go and use these sort of surreptitious, excessive grasp of power through the executive that are unheralded and unprecedented by law enforcement from the executive branch. That's not something we've seen before. And one of the reasons why is because in other situations, you would have accountability. But because of who they're targeting and how they're shaping this narrative, they are getting away with it more and more. And the large effect, the big term effect, the long term effect for this, Antonia, is that ultimately we will be in a space where the type of power that the executive branch has seized will be irreversible in order to get back.
Kim, one of the sort of hallmarks of this current era of aggressive, unusual tactics has been what advocates and families, immigrants describe as a real increase in racial profiling as part of the work to actually detain and find migrants and meet these sort of quotas set by members of the administration like Stephen Miller, who very openly pushing for sort of this impossible task of trying to get 12 to 13 million people out of this country in the next 3 years. And on that, a lot of those stops, the racial profiling, they've been dubbed Kavanaugh stops because of a previous opinion from the Supreme Court justice. But it was very interesting because in the recent decision from the Supreme Court that stops the Trump administration from deploying National Guard in Illinois, there's an interesting footnote from Justice Kavanaugh that I want to get your thoughts on. He seems to be trying to clarify previous guidance that had been interpreted as greenlighting racial profiling. And he writes in it, the basic constitutional rules governing that dispute are longstanding and clear. The Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. Stops must be brief. Arrests must be based on probable cause, and officers must not employ excessive force. He also talks and basically is trying to say that officers must not make interior immigration stops or arrests based on race or ethnicity. Again, as I've done this reporting, I've been out in communities and talked to people who've been part of these encounters. What you just heard the justice describe there is not how these things are unfolding on the ground. Do you think, because of the way they've been branded as essentially sort of being his fault, that Kavanaugh is trying to undo something, close a door that he already left wide open?
Well, he's definitely walking back what he wrote in a concurring opinion to one of these shadow docket rulings, these emergency rulings. The Supreme Court has been feverishly basically overruling lower courts, wait a minute, injunctions, meaning let's pause. Donald Trump, you need to hold off and let's see if this complies with the law. The Supreme Court's been rushing in and letting him do what he wants and then saying, we'll deal with the major case later. In one of these cases, there was a challenge brought to racial profiling, and the government was pretty clear that it does basically detain people based on whether they're speaking Spanish, whether their English is good, what the color of their skin is, their race, whether they're hanging out in areas that tend to be places where migrants work. And the lower court said, no, this is a violation of the Fourth Amendment. You got to stop this until we take a better look at it. Supreme Court came in one of these so-called emergency orders. And I say so-called because there's no emergency really in most of these, except that Donald Trump wants to do what he wants to do now and not have to wait till later. The court let this go forward. Kavanaugh wrote a concurring opinion basically justifying the suspension, I would say, of the Fourth Amendment in this context, saying immigration's really a problem. And sure, there's some evidence of violence in this context, but that's not before the court. And publicly, that became known as the Kavanaugh stop, essentially using that concurring opinion to, I think, shine a light on what the Supreme Court's doing across a number of constitutional protections, that is suspending them under this unitary executive theory of massive presidential power, which Charles mentioned earlier, is where we're going as a country. And I agree, in that opinion, he sort of slipped in this recent case involving the National Guard in Chicago. He kind of said, wait, I didn't really mean that. The Fourth Amendment says what it says, but Kavanaugh's, footnote is not going to lift that prior Supreme Court case that's still in place, that emergency ruling. And also, as Nancy mentioned, the Constitution's not self-executing. It doesn't have its own police force. If the Constitution's not enforced by the Supreme Court or enforced through the United States Congress against the president saying, wait, we don't like this, we're going to hold some kind of sanctions. And if the courts aren't empowered through a Supreme Court precedent to hold these officers accountable, what we have is a lawless presidency and a lawless executive branch when it comes to immigration in this moment.
So, Nancy, as it seems Justice Kavanaugh wants to put the genie back in the bottle here, do you think ICE is going to see this footnote and change their tactics?
Boy, if it seems like ICE doesn't see the Constitution, I hardly think they're gonna study the footnotes of a Supreme Court decision, directly. But part of it, again, is structural. Your opening was terrific. That when we were looking at the border and people with orders of deportation, sort of what we call targeted immigration movement, that's one thing. And then you go after people who either have an order of deportation, people at the border. But when you've expanded this to the whole country, and now you're talking about people who may have overstayed a visa, who don't have an order of deportation, may have overstayed, or even someone with a green card that you don't think they should have anymore. Now you're talking about not targeted stops, which opens the door to racial profiling, just as the LA case that was just discussed did. You open the door to racial profiling because you don't know anything else about the person. Right? You don't have a formal document, an order of deportation. You don't know anything about the person except the color of their skin and their accent. So, no, I don't think Kavanaugh can dial back what he did.
Charles, I want to get your reaction to a new filing in the Kilmar Abrego Garcia case. So a new filing revealing from a judge, Judge Crenshaw, that Garcia was prosecuted after being deported. The judge writes, quote, "The 2025 dates are pertinent because this is when the government decided to deport Abrego to El Salvador without bringing criminal charges against him. When Abrego successfully challenged his deportation to El Salvador and when the government changed its mind, returned him to the United States and initiated criminal proceedings against him." As you know, Charles, a trial was set with the government, going after and claiming that Abrego Garcia is connected to MS-13 and human smuggling. That trial that was just supposed to start in days, canceled. And now it seems a judge is considering the possibility here of vindictive prosecution. Do you think that's the direction that we're going? That can be hard to prove. But do you think in this case the facts are clear?
It can be. And I think that one of the things that stands out about his case is that in most of these conversations, Antonia, we're not talking about United States citizens. And so that's where people have been able to sort of navigate this notion of whether due process actually applies. And I think that in this instance, the notion of due process and maintaining its integrity is unquestionable. And that's why there's so much leeway for the courts to make this decision and to move in this direction, because the administration is dead to rights wrong when you look at the timeline here. And that's one of the reasons why this notion of vindictive prosecution can be on the table. In most cases, it is a very, as you've already discussed, high bar. As a former prosecutor, that was something that I could operate pretty much comfortably with as long as I was adhering to normal standards of ethics and doing things the right way. But when you lay out, as this decision has, or as this filing has, the timeline that's involved here, it paints a very interesting picture that I do think would help approach that bar. So this is a very unique circumstance in as much as it's usually not as clear or as clean, particularly in the context of this immigration discussion, but we may be able to see this play out in the realm of a vindictive prosecution moving forward.